I wish you all good afternoon, and please be seated as soon as possible. It's more than 3 o'clock, and I would like to get started, even though we don't have so many members present. But as the petitioners are here and ready to take the floor, let's start. I'm very happy also to find that the Vice President of this House, Mrs. McGuinness, is here. Very welcome. The UK authorities have been invited by a letter, but they have responded by a letter, a very thorough piece of information that I recommend all of you to read. So let's get started by addressing Marika Popova and Elisaveta Popova and Sabrina Curiou-McNeil. You are here, all of you? Yes, good. Up there. Fine. Welcome. I'll be happy to give the floor, first of all, to you.
I just arrived. You just speak. Start speaking. Introduce yourself.
Good afternoon. My name is Elisaveta Popova. Yes.
Keep talking.
Can I continue? Firstly, I would like to thank you for this opportunity.
You just keep talking.
Okay. I would like to thank you for this opportunity to give me the chance to be here. It definitely means a lot to me. First of all, I would like to start with my daughter, Megan, who is adopted in the United Kingdom without my consent. I've not seen my daughter since 8th of August 2013. My daughter was taken away on the basis of future emotional harm, and I was also labelled to be unfit parent with a diagnosis of having maladaptive sexual scripts. The person who diagnosed me, it was not qualified to put such diagnosis on me.
You can keep talking. You don't need to listen to this.
After that, I've put all my efforts.
Wait a minute. Is there a problem with the translation or something because you stop talking every once in a while?
No, I'm hearing it in the headphones. And
take off the headphones. That would make you much more comfortable.
Oh, thank you.
So please try again. Take your time. We are here to listen to you, and this is your moment. There is nobody else but you. Everybody's listening to you. Take your time and feel completely free. The interpreters are fine. They are transmitting your message to everybody in his or her own language.
Okay, I do apologize. So back to my last contact with my daughter. I've not seen her since 2013. Shortly before she was adopted, I put all my efforts to prove to the social services that I can be her parent. I signed up to be a qualified childminder. I've undertaken all the courses needed so I can be her safe parent. Nothing was ever considered by the courts. It was basically as if I've done nothing. I don't think I was treated fairly by the UK authorities. I also do realise that I do have mistake made in the whole process, but I don't think I deserve to serve a lifetime sentence because of mistake. I believe that I deserve a chance to be with her, and I want to be with her. Also, I would like to say that in my view, the British authorities have a motive to take foreign children. And I believe I'm not alone I'm not the only one with this opinion, simply because foreigners don't know the British law and the British system, how it operates. So such people are very easy to target. In court, I was treated like everything I said or did was used against me, even though it was positive. It was there to show them that I love and want my daughter. Everything was twisted against me, over-exaggerated. To me, these are the worst people you could ever deal with. And I'm here today because I know that my daughter deserves to be with me. I'm her biological mother. She's not better, she's best off with me. She does not need to be with strangers. The last time I saw her, she was really upset. I've never seen her like that. All of the pictures I have of her smiley face, never seen her so upset. The right to a fair trial, I do not think I was ever given such right. My right of family life, now all the doors to me to be a parent are closed. I even have a CRB check which says that I might present a risk to people everywhere I work simply because my daughter has been taken away from me. I don't believe that is fair.
How was your consent taken away?
Oh, my parental consent was dispensed with by Judge Plumstead in the county court. There were no reasons given for it, apart from the one that Megan deserves a better life with no risks or something like that, future emotional harm. To avoid it, she decided that she needs to take my consent away. The rights of the child were never considered. And none of the activities that were done by social services were, I don't want to use the word fair again, but I think that's the only word I have left. And as a European, I don't feel like a European. They tell me you have rights, your child have rights. Where are my rights? Where are the child's rights? I don't have contact with her. She does deserve the right to know her identity. She does not know who she is. She doesn't know who she is, who's her mother, who are her grandparents or any blood relatives. She doesn't know any of them. Why should her identity be wiped off? Today I'm seeking from you to tell me what is my alternative. What can I do so I can be with my daughter? What is my next, what should be my next step? All I want to know is that she's okay, that she's alive. I just want to know that she's good. Yes, I've been into British courts, county courts, appeal court, royal courts of justice. I've appealed all the decisions. None of my reasons were ever taken into account. Basically, everything I did, everyone was turning a blind eye to it. And yes, in life, people do make mistakes, but people change. People change, and people deserve to have the chance. I do apologise, my words do come out quite hard. I miss Megan so much, and all I want is to be with her, which is why I'm here today. And if my next step is the court, this is where I'll go. But I will never give up until I am with her. Thank you very much for your attention.
I thank you very much for having the courage to travel far and to come here and share with us your story. It's a heartbreaking story, and I think that every one of us would be equally moved. So thank you for your courage. And I would like to turn to the European Commission, to Margaret Toot. Please, the floor is yours.
Thank you, Chair. Good afternoon, everyone. Thank you to Mrs. Popova for sharing her story. And we understand how frustrating and heartbreaking your case is. It's a very complex case. And I think there is never a win-win situation for cases like this. In the context of the rights of the child, let's not forget that the national authorities, the UK authorities in this case, have a duty to protect children and to act where there is a risk to a child. So let's bear in mind the starting point. We cannot comment on individual cases. We were not in the various courtrooms. We are not here to judge what the UK courts have done. We have looked very carefully at all the material that has been sent to us, and we have listened very carefully to what you have said. I'll hand over in a minute to my colleague Joanna Serdinska from the Civil Justice Cooperation Unit in DG Justice, and she can better explain the remit of the Brussels 2A regulation in the context of parental responsibility. In terms of what we have listened to in this case and in other cases on custody and adoption without parental consent, bearing in mind there are generally two types of adoption, with consent and where parental authority is removed. We will, where we can, take this into account in drafting a Commission communication on integrated child protection systems, the aim of which is to tackle some of the cross-border challenges and find ways to improve coordination and cooperation. We also have been funding over the last couple of years capacity building in the area of child-friendly justice, so training for judicial and other practitioners on the rights of the child, especially on the child's right to be heard and so on, so that more people are very well trained on rights of the child and can work in a multidisciplinary way. But perhaps now I can ask Joanna to share with you some information on Brussels.
Good afternoon. If Chair allows me, I would like just to say a couple of words of this case in the context of Brussels 2A regulation. This is another case because some of them we also were heard by this committee on the previous occasions. And as much as my colleague said, the circumstances of the case are saddening us. We need to see in how far this case would or would not fit into the context of the Brussels 2A regulation, which is the regulation on parental responsibility inter alia. So the decision itself on adoption is not covered in the Brussels 2A regulation. You will know that it's just the responsibility of the member state to deal with the adoption cases. But nevertheless, Brussels 2 regulation should facilitate somehow cooperation, especially in the judicial cooperation in all cross-border cases. So from this point of view, we looked at the files submitted and have analysed them. as said, the decision on adoption being a decision on the substantive family law, it's a decision on adoption, even if this is not in Brussels, covered by the Brussels II regulation, so we could not find, so to say, a kind of link with this to investigate further in this direction. I think it's a very good position taken by the petitioner who does not agree with the decision on the substance. And of course, it might have been, and this we just do not know, well, you allege that there were your fundamental rights of your child were, so to say, infringed in this case, and it's your right also to submit your application to the court in Strasbourg, because this then, the decisions which are not falling under Brussels II regulation, but then it cannot be, so to say, investigated by the Commission or in the light of the Charter of Fundamental Rights in this specific situation. There can, of course, and they need to be reviewed by the court in Strasbourg from the perspective of the potential infringement of your fundamental rights and of your child. The second thing I wanted to say, I read carefully also so to say, the whole procedure you've been through in the past months and years. And I must say we also take account of this because we did discover that even if the central or the national authorities, they are not, so to say, following any of the cooperation mechanism of Brussels II regulation, there are some gaps in there. And one of the gaps you have highlighted in your documents where you pointed out to how the procedure for taking of evidence was done in Bulgaria and so on. But I must say none of these obligations are not covered, so to say, in the Brussels II regulation. So therefore we could not identify as such any infringement of the provisions of Brussels II regulation, but we do take a note of the procedures and considerations that the court signaled in its decisions. Thank you.
I would like to know if the Bulgarian embassy is present. No?
Bulgarian embassy.
Yeah.
Yes.
Exactly. Would you like to come in on this?
No, unfortunately, I'm not in a position to comment, but I will transmit all the information back to my authorities. Thank you.
I also heard that the grandmother who is present here, Ellie Popova, also the petitioner, that you would like to take the floor for a brief comment, or you have something to add to what your daughter has just said. So feel free to take the floor.
Добър ден и
I think you are more comfortable to sit down.
че мога да присъствам тук и ми давате тази.
Thank you very much indeed for giving me the opportunity to speak.
Sit down, because then the micro will transmit the sound for the interpreters. Otherwise we cannot hear anything.
Thank you. Thank you. Сега трябва да слушам. Добре. Така, значи аз много ви благодаря, че ме допуснахте и имам тая.
Thank you very much indeed for having given me the opportunity to come here. In being here, I'll be able to now give you my comments. I'm Megan's grandmother, and I have fundamental rights too. I have the fundamental right to be able to look after and care for Megan. Our family was never in agreement with Megan being adopted by strangers, complete strangers. We don't even know what ethnicity the family is. We would like Megan to keep her Bulgarian identity. Nobody can contest that. And these are fundamental rights that have been violated. We have been rejected in our case, following the evaluation or the assessment made by a social services official. This person didn't know the facts. never informed the Bulgarian competent authorities of any of the information. She went to Bulgaria, made her assessment and didn't even let the authorities know. The social services official didn't even notify the child protection agencies in Bulgaria, nor did she speak to any of the people in the town where we lived. So there's been no cross-border cooperation here. Nobody spoke to anyone in Bulgaria. And it's important to bear in mind that the father is English and the mother is Bulgarian, which means you have to respect international law. And we should be applying international law in this case, because there are two countries involved. The social services official made a report of 200 pages. Only 23 pages were actually translated, and the Cambridge Tribunal totally disregarded me and what I had to say because I wasn't able to avail myself of interpretation services. So I couldn't speak, but in the 23 pages that were translated, I was able to read in that document that my husband and I were not deemed capable of looking after our granddaughter. Now, in Bulgaria, there were 2 reports drafted, and in those reports, we were deemed fit as grandparents to look after our granddaughter in those 2 reports. Now, each time we've gone to court in the UK, I wanted to speak, I wanted to take the floor to make comments. And at the Court of Appeal in London, my request to speak was rejected, so I never even had the opportunity to speak there. I'd like to add that there has been no direct contact or the possibility to have a relationship with my granddaughter. We're not even allowed to see her. There are many things I'd like to say to you today, but unfortunately time is limited. What I would like to say is that my husband and I, so we as the grandparents, we have given a guarantee before the British court that we are fit to look after our granddaughter, and we are able to do anything for this girl. We want her to be in a family environment. We want to protect her as our granddaughter. We have made this very clear. We've set out all of these things in this document which we submitted as a guarantee for the court. Now, all of the courts that we've been to, the high courts and the appeal courts and all of the other courts we've been to, we've been saying the same thing, and we've constantly been disregarded and ignored. I've never been able to speak, though, so my fundamental right there has been violated. I've never been allowed to see my granddaughter. And people constantly kept telling me that I wasn't able or fit to look after my granddaughter. I want my granddaughter to come back to Bulgaria, to learn her mother tongue, to get to know her family. Today she should have been able to speak Bulgarian. You cannot argue that this child is just English or British, because her mother is actually Bulgarian. Without a biological mother, you can't even have a child, can you? So you have to respect both the legislation pertaining to the nationality of the father, but also that of the mother. So, you know, we have to respect both sets of legislation. Why on earth, in these circumstances, would you take a granddaughter away from her grandparents and place the child amongst strangers? Thank you very much for listening to us and taking the time to consider this. But let me just ask you this. Who do we need to go to find out what we have to do to get Megan back into our family? I really don't know where we have to turn. People keep telling me that there are British authorities and British people we should speak to, but, you know, we're alive. We are the grandparents, and we want to look after Megan. We've given documented evidence of our financial means, and we have other children that we've looked after, so of course we're able to look after our own grandchild. You know, I'm a citizen, a responsible citizen. I've brought up 3 of my own children. I really don't understand this situation at all. I have another question for you. Now, you are all aware of the facts. You have no doubt read the document provided. So my question is, who can get Megan back for us? Is there a body we can turn to? Is there an institution here in the European Union who protects the rights of the biological parents? Who could take a legal decision in order to annul what has been decided by the British courts? Who can get our daughter back to us? The final thing I want to say is the following. A few days ago, my son asked me, why is Megan not coming back to us? I've never seen her. I want to play with her and make the most of time with her and her life. What can I respond to in the face of that question? What can I answer? What can I tell my son? What really am I able to say to him? Should I explain to him that the high courts in the UK are refusing to give us our grandchild back because they believe that we're unfit to look after her? But that's not true, is it? We have a home, we've got a whole bedroom prepared for Megan, especially for her. We've even done work in the house to make things better for her. We've done everything possible to make it possible for her to come back to us. Our granddaughter is Bulgarian. Nobody can deny that. She's half Bulgarian, half British. You cannot simply take this girl away from us. You know, she exists, she has a mother and she has two grandparents, so it's not possible just to hand her over to strangers. Who then can annul the decision taken by the British courts? That is my question. I don't even know if my granddaughter is happy today. I don't know if she's faring well, feeling well mentally, how she's developing. Do you think I can just let this go? Of course I can't. I have a granddaughter, but I don't know anything about her, and that's not normal, is it? So what I want to say is all of these measures that have been taken regarding the adoption of my granddaughter by unknown people, by strangers, you know, that is not in the interest of Megan, nor in our interests. Megan should know who we are. She should know her grandparents, her roots, her country and her language. Who is going to be able to console Megan the day when she understands that she was adopted, that she doesn't have a country, that she doesn't have a mother or a father? The day she understands that all of a sudden she was adopted by people of a different ethnicity. Thank you for listening.
Very much for your intervention. It is, as I stated before, it is heartbreaking, and we fully understand. Now, we are not a court, and we are not here to judge anybody. We are just here to try to examine the petition and the situation, and therefore I'm now opening the floor for colleagues to come in on this so that we can see if there is a way to find a non-judicial remedy for this situation. This is what we're here to examine. So first of all, I would like to give the floor to Mr. Radev.
Благодаря, госпожо председател. Уважаеми дами и господа, Bulgaria.
Thank you very much, Madam Chairman. Bulgaria often comes in for criticism because of its legal system and its judiciary. But in the case of Megan, I must say that I'm very surprised about the British legal system. We talk about mutual trust and confidence in the courts and in mutual recognition and so on, and reinforced judicial cooperation. In this particular case, it seems to me that the judge has failed to comply with the provisions of Brussels II with regard to establishing contact with the central authorities in the country concerned, because the social services were sent in to gather evidence on this particular case without informing the relevant Ministry of Justice in Bulgaria. The well-being and the future of a child has been neglected. At a time when there is EU legislation by which has not been respected. EU law takes precedence over national law, after all, and we should be able to avail ourselves of its provisions in order to protect what is dearest to our hearts. I believe that the treaties and the conventions should apply, and I think that's the only way we can guarantee the future of this Bulgarian family. Thank you.
Thank you very much. Ms. Gabriel.
Благодаря, госпожо председател. Аз също смятам, че след изслушване.
Thank you very much, Madam Chairman. I feel that having listened to the petitioner's case this afternoon and on the facts of the case, we in the European Parliament cannot remain stony-hearted in the face of a human tragedy. And I would just pick up what Mr. Radev said a moment ago. As co-lawmakers in the European Union, we must ensure that EU legislation is respected. And in consequence, we need to push for the respect of Brussels II by the British courts and the British legal system. I think that there are certain elements here which have been enumerated by the petitioner. We have to ask certain questions. To what extent is it fair or just to deny a mother custody? We're talking here about someone who speaks English fluently, and I think that you can clearly see circumstances which would justify her being deemed to be capable of looking after the child. Now, why was a decision taken to the contrary? That was clearly based on an interview, a conversation with the grandmother. She said that she still supports her daughter, someone who is well educated, is respected in the community, a mother of 2 children, developing perfectly well and doing well at school. I wish also to salute the actions by the consular services in London seeking to ensure respect for the rights which Bulgarian nationals abroad enjoy. It's very important for colleagues in the European Parliament to know that the representatives from the consular services have been involved and informed the Minister of Justice with regard to the infringement of Brussels II. The question then is who authorised the social services to carry out inquiries when it came to those seeking to have custody without informing the central authorities. In other words, the relevant departments of the Bulgarian Ministry of Justice. It seems to be the case that the Cambridge Court in question has allowed itself, saw fit to order those inquiries without informing the home authorities. In that way, here in the Parliament, the European Parliament, we must ensure that all of the legislative practices in the Member States respect EU legislation, and that is why I want to hear the response from the Commission, because they are the guardian of the treaties. What can we do to ensure that EU legislation is respected to the letter? And then finally, can I call on colleagues in the Petitions Committee with an appeal. The only hope that we have now is the European Court of Human Rights in Strasbourg. Is it possible to speed up the process, to fast-track proceedings with the court in Strasbourg? After this hearing, Madam Chairman, together with Mrs McGuinness, I think that we should send a letter to the court in Strasbourg setting out the minutes from this meeting today. For us, the most important thing is that we have written support, black on white, for everything which has been said in our discussion this afternoon here in the committee, because I feel I'm sure in saying that all of us support the petition which has been laid out for us this afternoon. But the fundamental fact is that we must stand up for respect of European legislation in cases such as this. Thank you.
Thank you very much. Mr. Malinov.
Благодаря. Аз не знам дали трябва да се излиза извън емоцията.
Thank you very much, Madam Chairman. I don't think that we should seek to take on a legal capacity, a legal function. Of course, we are politicians and we sit here on the Committee on Petitions. But, of course, we cannot be impassive when it comes to an emotional case such as that. We cannot remain indifferent. And I think we must do everything in our power to put an end to forcible adoption of children across the European Union. And let's call it what it is. It's forcible adoption. And can we avoid this kind of forcible adoption? This is not just one particular case. Let's think of all the other cases which have happened and may happen in future. We cannot turn a blind eye to this. This is the United Kingdom, and this is a practice which has been observed in the UK, which is dubious. We don't know whether this is illegal or not. But I think that the overriding problem is that it is a practice which exists in the United Kingdom. This happened to be a Bulgarian child. Let me quote from the Charter of the United Nations on the Rights of the Child. It talks about the parties to the Convention not permitting children to be taken away by force from their parents unless there are cases of maltreatment by the parents. If the parents are separated, then due care must be given to the place of residence for the child, end of quote. Now, in this particular case, there is no problem, there's no difficulty when it comes to custody. Both parents are there. The father has no ill will against the child, and it's possible for the child to be restored to the mother and to return to Bulgaria. And I think that this is a case where we can be influenced by our emotions. The British authorities have behaved in an unacceptable fashion, and I have yet to understand how it could be decided that the grandparents could not look after their grandchild. There are many towns in Bulgaria. Many citizens in Bulgaria have been outraged by this and are indignant. And this is not one isolated case. It simply attests to the fact that there has been discrimination, even if in legal terms you cannot, that is not an enforceable concept. But the European Court on Human Rights in Strasbourg is perfectly straightforward in its case law. And I think that perhaps is the institution which will be able to find the solution. I suggest, therefore, that this petition be left open, and we must now seek the advice of the Legal Affairs Committee of Parliament, jury, because that, I think, is the parliamentary committee with responsibility, ultimately for parental responsibility. Certainly we must do all we can, qua Committee on Petitions, to accelerate and speed up the processes vis-à-vis the court in Strasbourg. Now, it was very difficult to listen to the words of a mother who is sad and who has to give an account of herself to see whether she comes under the ambit of Brussels II. That is a very sad thing to have to listen to, having to make that case. However, I must say that it's clear that the Committee on Petitions here, yes, there is a regulation which has to be complied with, but there is urgent and urgent. In that case, the 6-month period means that Megan will be 3.5 years old in 6 months' time. And currently, Megan is staying with her adoptive family. I hope that is a good family. But I don't think that you can treat the mother and the grandparents in this way. This is no way to treat the child either. And this is a very sad case. And we must do all we can to help the family. Yes, we must maintain our impartiality. However, this is a clear case of discrimination. And more than that, this has given rise to outrage with many people in Bulgaria. Europe must demonstrate that it's capable of responding. Not everyone has the necessary legal background to understand the ins and outs, but so much is clear. Thank you very much.
Thank you very much, Chairperson. I'm here really because of my role as children's mediator, as Vice President of the Parliament, and I want to thank my colleague PTR and indeed the Petitions Committee for engaging directly with my office, because I think we have a lot of work to do and we could do it better collectively. So thank you for that initiative. I want to make some general comments before I speak to the specific petition, and of course to thank the petitioners for coming here in what is a very difficult set of circumstances. I think first of all, I worked on the Petitions Committee in the past, and we are not a court, as you so rightly pointed out, but we're certainly a resource, and we provide an opportunity for people to come and air their problems, and we try and assist them. Secondly, I am going to try and remove the emotional aspects of this story, because I'm a mother and I couldn't imagine what would happen if somebody had taken one of my children and given it up for adoption. So, I mean, I sympathise, and I cannot probably understand the feeling of both the mother and the grandmother here today. However, every member state has a system of child protection, and we cannot decide here what are the circumstances of this case because we don't have the file. And even if we had the files, we are not social workers, we cannot make judgments. So let's remove ourselves from the detail and look at some of the general comments here, which I think are instructive. We need to understand, are the member states taking full account of, in particular, the best interests of the child, because this is part of the Charter of Fundamental Rights. So this is a key issue. Are the voices of the families being heard, including the grandparents, because this is a key issue. And fundamental to all of this is that in many member states, family law is held in secret. So we don't hear and know and understand what is happening. In my own member state, for example, we are beginning to get information not on the detailed personal cases, but on general trends in family law. But this is a problem for policymakers to understand what's happening. I certainly am determined to work with this committee and indeed with the Commission, and I'd be very interested to follow up with meetings about what work you're doing, and with the network of children's ombudsmen across the European Union, because this also is an issue for the Ombudsman's Office, where they look after children's rights. Now, the problem is that what I'm proposing is a long-term issue. It will not solve the immediate problem. So I'm going to come to the immediate problem, if I may. I think any family that takes this situation so far as to come before a parliamentary committee to bare their soul is certainly longing to be reconnected with their child. So what I would suggest, as the Commission have proposed, is that the best course of action, in my view, and my colleague Maria Gabriel has made the same comment, is the court in Strasbourg. And I'm not sure of what time will be available there and to get this case heard, but it seems to me to be the possible legal avenue. The difficulty for us as a petitions committee or as parliamentarians, and I've read just once the reply from the UK authorities, they will not discuss individual cases. We cannot overthrow a decision made in the UK. But this case highlights not just the UK issue of adoptions without parental consent, which I thought was a thing of the past, because we are now researching the past history of these things in many countries. And this is the difficulty for us now, to look at the situation of this individual case, but also to take on board the circumstances of it, which are mirrored in other member states, and try and give a European response. So to some extent, and I'll summarise, Chair, because time is short, I'm going to study very carefully this particular case. I think that the family have done a service perhaps to families across Europe because they have been prepared to raise their personal and private story before this committee. So at least we owe them that we investigate what we might do around the European issues that are unveiled in this. That said, I don't think Brussels II is part of the answer, unfortunately, because this is a case of adoption, except where the parental issues are not being fully adhered to, and indeed possibly where the contacts with the authorities in Bulgaria may not have been sufficiently thorough. But again, I'm making judgments here without knowing the full case. So in summary, I thank the petitioners. I can empathise with them. The difficulty we now face is that we have a family that have adopted a child that clearly will have a family relationship with this child, and we have a family that has lost a child. So I'm not sure how this future will work out. I hope people can, be resolved in this issue and that the child is well cared for. But I think there are issues here that span Europe, that are not just British or Bulgarian, but they're European. And I think the Commission in its future work, and certainly in the work I will do, need to address these issues. So again, thank you for giving me this opportunity to speak. Apologies, it's been a lengthier intervention. It is helpful that I hear exactly what is going on, and I intend to maintain very strong contacts on this case and indeed on any other issues around child protection that come to your attention, Chair. So thank you very much.
Thank you for your intervention. It was good and lengthy. It's not always the case that but it's really interesting to go into this in depth because it's needed. It's something that highlights a cross-border problem that we're encountering, and we're facing that in Europe. Various issues. We have a number of petitions. This is not the only one. So I would dare to say that this is a systematic thing. It's not one individual case. But what the family, and as you rightfully pointed out, what this family is doing here is to raise awareness on something that goes on a systematical way. And therefore, this story might serve very well other families in the future when we together try to work this out. Personally, I believe that discrimination is an essential part of this, and together with my colleague, Mr. Malinov. Now, we still have a number of speakers on the list, and Pal, the floor is yours now.
Kedves elnök asszony, én nagyon rövid leszek. Két dolgot szeretnék mondani.
Thank you very much, Madam Chairman. I'll be very, very brief. In my comments, there are 2 points I would like to make. Now, first of all, this is not the first time. However, when things come from the UK, it does seem that something is slightly wrong with the procedures being followed by the British authorities. I hesitate to say that there is something rotten in the state of the UK, but it does seem that there are systemic problems here. And I would support colleagues who said that we should keep this petition open. And I suggest that a letter be sent to the British authorities in which we call upon them as soon as possible to address the issues here in cooperation with the Bulgarian authorities. And I suggest to Bulgarian colleagues that they become proactive here.
I find it very encouraging that we have many Bulgarian colleagues here today, colleagues that not always attend the Petitions Committee meetings. So very good. On the contrary, it's a bit shocking to find that we don't have even one British MEP here today. So they were all aware of it. Anyway, Peter, the floor is yours.
Vielen Dank, Frau Vorsitzende. Und ich möchte auch nur noch ergänzen, weil...
Thank you very much, Madam Chairman. anyone who is a parent or even a grandparent is going to have to keep the emotions at bay in order to keep a focus on the situation. And I think that someone said this is no way to treat a child, and of course the question is you can go through the legal processes, but the child themselves has got rights which need to be factored into the equation. It was said quite rightly that this is not just a petition from the UK. The UK is involved, but we've had a series of petitions coming our way where one has an uncomfortable, an uneasy feeling that something is not that quite right and that something is amiss. Now, you could say that we've got Brussels II, there are areas where the member states are competent, but one of the Brussels II provisions is the duty to cooperate. And when it comes to children and allowances and things such as that, it's not sufficient to say, well, we have taken a decision and that's the way it's going to stay. There is an obligation for cooperation, and I believe that there's room for the British authorities to be cooperative with, for example, the Bulgarian authorities, and for the case to be directed or sent to a Bulgarian court, which could look at the possibility of the grandparents, for example, taking custody. I think that there is an absolute requirement for cooperation. This is not something which can be unilateral. And this is not something where you can have a decision which is taken once and for all time. Decisions can be taken which will be provisional for a particular period in time and limited in time. And it's not sufficient to be simply inform the authorities, in this case the Bulgarian authorities, of a decision which has been taken, as it were, irrevocably. And I think we've got to push this notion of cooperation. It's not simply telling the other side what you have decided. Cooperation means a spirit of cooperativeness, and I think that the British authorities, it seems to me, would fall down if that were the test which were applied. And the ultimate test has to be the best interest of the child. So I suggest that a letter be sent off to the British authorities, and the Commission, I think, could delve deeper into what the term cooperation should involve in this case. Now, possibly adoption under British law is a decision on adoption is definitive and final and irrevocable. However, I think if that does prove to be the case, one can expect more harrowing cases such as this, and we do need to look into this in greater depth and see whether the cooperation aspect of Brussels II is being fully respected by the member states. They do say that politics begins by looking reality in the face, and if there's something wrong, then you've got to imagine ways of changing the real world. And can we change things? That's really a question to the Commission, ultimately to the Council. We want the European Union, we want European citizenship. But if you are going to be logical, this has to be extended to the rights of the child as well. And children should have the protections from the EU as well, and that has been lost from sight, I believe. Thank you.
Thank you, Peter. Mrs. Kuneva.
Благодаря ви много. Ще говоря на български, независимо, че съм депутат от...
I'm going to speak Bulgarian, even though I represent Greece. I would like to give my support to this Bulgarian family. It's a family which has come here to explain their case, but I think it's a case which concerns the whole of Europe. It's not an isolated case, it's a current practice. I've read statistics according to which this practice started for the first time with Turks who came to Europe to work. It was then applied to other citizens from other countries. The statistics say that 2% of children who are taken away from their families are then put up for adoption. We know that there is European legislation here. But we are talking about policy here, European policy, and there may have been an error, there may have been a mistake. If this can still happen in Europe, it's wrong. I hear that the same practice exists not only here, but in Australia and the United States, but also in France and Norway and the United Kingdom in Europe. So we have to find out what went wrong to prevent this happening again. We have to take into account other forms of abuse which exist. In Bulgaria, children are taken away from their mothers and put in foster families which often don't feed the children, don't change their nappies, let them be vagabonds in the street. The fathers of these foster families are drunks. They beat the mother, or the foster mother rather, and these poor children live in misery. In fact, in Bulgaria there is misery, and people are not always able to bring up their children. Sometimes mothers know before they give birth even that they will not be able to bring up their children. 600 livres or 300 euros are given as an allowance to mothers when they give birth, but that's not enough to raise a child in Bulgaria. So there's something wrong with European child protection policy. I have looked at the correspondence between the various bodies in the context of this petition. And it's my impression that the grandmother is a very intelligent woman who deserves our trust. The fact that she has brought up 3 children herself proves this. Thank you very much.
Thank you. And now the floor is to Mrs. Pitera.
Dziękuję, Pani Przewodnicząca. Thank you, Madam Chair. I wanted to point our attention to a slightly different angle of the problem. I have the impression when we listen to yet another petition which concerns the children, that here we are talking about infringements of the rights of the party in judicial proceedings, because this is yet another petition when the claimant says that the documents were not translated into his or her language. So I think that regardless of the very dramatic descriptions that we hear every time, there is also yet another problem here. So is it really so that the courts in Great Britain, because these are the petitions we've been seeing recently, do not respect the rights of the party in judicial proceedings? Maybe it would be good, I still haven't come up with a solution, but maybe we should check how the proceedings run in the courts in the UK. Maybe the people whether the people do have any legal assistance, because if they don't have money for it, they should get it from the state. Do they have access to translation? Are they treated as full-blown citizens when it comes to the rights they have as citizens of democratic countries? So this is my remark, but I think maybe it could also explain or help to explain the whole series of judgments we are talking about, because they are often being passed with the very limited rights of one of the parties. Thank you.
Thank you very much. I think we've had an interesting and fruitful discussion, exchange of views, where one colleague is adding to another, and all of a sudden we see a pattern. This is what we could do and maybe should do. So now I wonder, do you as petitioners want to have the floor just for a very short remark?
May I just add a little bit, please? Because I am Sabine McNeill, who put together the systematic patterns on forced adoptions and, in addition, child snatching in the UK. Because I would like you to know that only 4% of the children who are put into or taken into care are actually adopted. I don't have the statistics of how many get returned, but I can assure you that adopted children are not always only in happy families. And I would love anybody and everybody to come and check what's going on in the courts. I've just been in 2 courts in the Royal Courts of Justice last week and this week. It is so appalling. It is so disgusting. When you're reading a judgment, you are told that black is white and white is black. And you only believe it when you know somebody like the petitioner yourself. And that's why I'm so proud of Ellie, of whom I've known before, because she has raised 5,500 Bulgarian signatures. That's even more than on the petition to abolish the forced adoption. I just beg you to listen. I beg you to take us seriously. It is more serious than we can imagine. You have to know what's going on. So thank you for giving us the opportunity.
Thank you for your contribution. Okay, it will be very difficult for me to summarize this. Very difficult. One thing is for sure, that we are keeping the petition open, and I personally would like to see if maybe the committee would like me to together with colleague Mrs. McGuinness, who is actually working as Vice President with children's rights, that we could just sit down together with the Secretariat in the Petitions Committee and seek contact with the Commission in order to try to find a way forward in this. And then that we could come back to the committee and give a report on what we sort of got. So let's take stock of the instruments that we have and try to elaborate a way forward. Would that be something that colleagues would agree to? That's excellent. So then we do that, and we'll keep this open and by all means a living question. Would the petitioners be happy with that? Okay, thank you very much. That's what we do. And Commission, be prepared that we're going to give you a call. Excellent. Thank you for your contribution also. Now,